Hello, my name is John Milburn. Today I'd like to speak about Chapter 8 of Jerry Bates' publication, Environmental Law in Australia. Chapter 8 deals with strategic environmental planning. Firstly, you recall from previous discussions, the common law had no concept of public planning. Private owners could effectively plan in a very limited way through using restrictive covenants. We would see that typically in estate developments, where the developer wanted to ensure that people who were building within the development did so to a certain level or consistently with a certain style. But in the common law, that was really the extent of any form of planning. As we discussed, environmental law is a new area of law, and largely it's statute-driven, at least in terms of providing the overall structure and framework for the environmental law. So the concept of planning is critical to the concept of environmental law and implementing environmental law policies. The alternative to strategic planning is, of course, making decisions on a totally ad hoc basis. But planning, particularly strategic planning, introduces a measure of order, certainty, and security. Planning stresses the need to introduce the order and avoid overexploitation by managing the resources in a sustainable way. So in essence, strategic planning is simply managing for the future. And strategic environmental planning describes the preparation of plans and policies at the state and the regional and local levels. And you'll recall from previous discussions the hierarchy of how those various instruments are regarded in those three levels. So let's talk about the theory of strategic planning. One theory is that if it impacts on the resources and is accounted for at the outset, then subsequent developments or projects don't need as much or as rigorous an evaluation as might otherwise be the case if the planning was done on an ad hoc basis. So allocating land and resources from the Crown. You'll recall previously we talked about the Crown as this overriding entity which stands apart from Parliament and stands apart from the courts. It is, if you like, in the context of a family, similar to the household. So the Crown takes control of resources on its own land, Crown land or public land, but also through an exemption or an exception in the deed of grant of land, also deals with the power to regulate natural resources that might occur on or even under or pass through private property. So things like minerals, petroleum, geothermal energy and water are all things that are reserved to the Crown to control, as is the case, of course, for fishing. That is where it occurs within Commonwealth sovereign areas. There has been a considerable change of emphasis over the past 40 years. In the past, the economic exploitation of Crown land was always considered desirable, subject to negotiation of satisfactory agreements. However, that's not necessarily going to be the case now. It's not going to be regarded as an automatic or unquestionable process. It is just as permissible now to argue for the preservation of the environment in its natural state as it is to press for it to be developed. Increasingly, knowledge about the interrelationship of the ecosystems and biodiversity and the promotion of the concept of ecologically sustainable development testify to the growing need to conserve biologically and aesthetically, as well as culturally, certain important aspects of the natural environment. Once the use of public land has been determined, then management plans are drawn up to facilitate the way in which that property is used and to avoid detrimental environmental impacts. Environmental management of natural resources under the control of the Crown, whether it's on land or in oceans or within the bounds of private property, is commonly undertaken through the production of this environmental management plan that I mentioned. Environmental or resource management plans are required by legislation for environmental management in most natural resources that are vested in government regulators. And these plans might be broadly divided into either strategic plans for the management of a resource, such as natural parks or reserves, forests or fisheries, or plans imposed on specific projects for the environmental management in the conduct of a particular activity, such as mining or the extraction of gas or geothermal energy or petroleum. But either way, plans must comply with the objectives which are set out for decision makers in the Act, and decision makers must act reasonably and impose conditions that are relevant pursuant to the terms of the overarching Act. As a form of delegated instrument, conferring upon the executive power to make decisions, management plans must accord with the objects of the legislation under which they're prepared. For example, Section 117 of the Nature Conservation Act of Queensland provides that in Queensland, management plans for reserves must be consistent with management principles specified for a particular class of reserves. So the point is that care taken at the strategic planning level may ultimately save a great deal of time when assessing particular development projects or proposals. At the next level down to management plans, we have the body of work contained in codes of practice and guidelines. And those codes of practice may contain elements of strategic planning, as well as providing practical guidance on how to conduct permitted activities. You'll recall that in Queensland, the standard planning scheme provisions provide for the overarching, if you like, framework. And those provisions allow for the standard use of overlay schemes, for example, in relation to good quality agricultural land or coastal management or biodiversity principles. So in Queensland, there are those overarching guidelines. We also have the ability to enter into resource agreements, which are agreements for the management of natural resources. And these agreements can be made between governments or different agencies of governments, or between government and private landowners. So that's resource agreements. We also have private agreements, which are agreements concluded between government agencies and private landowners, and they may enhance or enable strategic approaches to natural resource management. These appear in various forms of planning agreements or heritage agreements, conservation agreements, or property agreements. Now, here's an important point. Those property agreements effectively bind the land, not the person. So the land is burdened, if you like, with that agreement, and it will therefore bind future owners who subsequently own that property. You'll see in one of my videos I've undertaken some commentary in relation to the sorts of search inquiries that you might take if consulted by the purchaser of land and you're keen to ensure that the purchaser of the land is aware of any property agreements, for example, that may burden that particular property. Environmental planning is the framework for land use, and environmental planning is the most important general means for managing the environmental impacts of a development, particularly at a state or local level. It is often the framework within which members of the public get their best chance to influence strategic planning, as well as the ability to comment on or even appeal against applications for development. Environmental planning instruments. Now, these are the objects of strategic environmental planning that are delivered through the environmental planning instruments. So, Section 4, for example, of the Sustainable Planning Act goes further than simply expressing the objects of the legislation. It says that where a functional power is conferred on an entity, the entity is instructed to perform the functional power in a way that advances the purposes of the Act. And we talked previously about the principles of ecological sustainable development, which are enshrined in the Act through sections 4 to 11 in particular. So when we talk about advancing the purposes of the Act, we look to the legislation where it makes it clear that decision makers advancing the purposes require ensuring decision-making processes are accountable, coordinated and efficient, take account of short-term and long-term environmental impacts at local, regional and state levels, apply the precautionary principle and seek to provide equity between present and future generations. Generally speaking, strategic planning takes place at 3 different levels, that is state, regional and local. But Section 41 and Section 42 of the Sustainable Planning Act allow for states to attach a greater or lesser degree of legal status to environmental planning instruments. In Queensland, a state planning policy, which is at the top of the hierarchy, provides that it has legal effect throughout the state unless the policy states otherwise. Environmental planning instruments commonly seek to achieve their objectives by introducing requirements for projects and activities. Now, the advantage of state or regional plans is that implementation of government objectives is not left to the discretion of individual councils or planning authorities. Otherwise, they might have a diverse range of possible approaches and standards in the way in which developments are realised. So the statewide or regional planning enables governments to coordinate a response to a particular thing by directing, essentially, that local governments apply common standards throughout the states. The use of local planning schemes does not, of course, automatically mean that all non-conforming uses of land covered by a scheme have to cease or close down. Existing non-conforming uses are generally allowed to continue by legislation until they determine naturally or they're abandoned. Section 28 of the Sustainable Planning Act provides that key elements of regional planning schemes should identify the environment and economic and cultural resources to be preserved. So integrated strategic planning is developing natural resources and environmental values to recognise the reality that the environment is an integrated unit. That then brings me to the end of my summation of Chapter 8. Later chapters will deal with different aspects of development process, environmental impact assessment of proposals, protecting and managing impacts on biodiversity, and dealing with pollution control, management of natural resources, waste management, and climate change. Thank you.